so.
Mr. Robbins, if you can turn your video off until we call your case. Thank you.
Thank you. As soon as I finish, you can go back out.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention to the court is now sitting. God save the United States and this honorable court.
Morning, everybody be seated, please. Welcome to the Fourth Circuit. And are we missing one of the lawyers on screen here? There we go. So our first case is Al Saba versus World Business Lenders. Mr. Rosenfeld, I understand you had a time trying to get here, so we're glad to have you by video.
I did, Your Honors, and I want to thank the court so much for the accommodation. I really appreciate it.
Well, it would have been a long walk, so we'll be glad to hear from you.
May it please the court, Your Honors, my name is Steve Rosenfeld, and I represent the defendant and appellant, World Business Lenders. In 2014 and 2015, a man named Gene Agbajabi defrauded the plaintiff out of a substantial amount of money. In January of 2015, he used $360,000 of that money to buy himself a home without the plaintiff's knowledge. This case poses the question of whether WBL, a lender who more than 2 years later lent money to a business that was owned by Mr. Agbajabi, with that home serving as collateral for Mr. Agbajabi's personal guarantee, could substantially assist his long completed fraud. Fraud that the plaintiff had already discovered, fraud that the plaintiff had already filed a federal lawsuit against Mr. Agbajabi, alleging that he met all of the elements of the tort of fraud and had including damages, and fraud that plaintiff even filed a lease pendants on the home that's in question here based on that lawsuit alleging fraud. All before WBL gave Mr. Agbajabi's company the loan in question, that is loan number 3. So as a matter of law and a matter of common sense, frankly, WBL could not have substantially assisted that completed fraud. And we believe that the district court's conclusion to the contrary misinterpreted the law and required reversal.
Well, is it necessary to find for you that we would agree with that characterization? I mean, it seems like that there could be either continuing fraud, if there was such, or separate acts of fraud, and so not as a matter of law would that act as a necessary affirmative defense for you.
Well, we believe that that there are two errors, Your Honor. One is as a matter of law, and I believe that when you look at the fraud that the district court seized on, that is the fraud having to do with loan number 3, which was the purchase of the use of the funds to purchase the house. And the district court claimed that we aided and abetted that fraud. And I think that there's been a misinterpretation of that, and plaintiff's briefs, I think, to this court furthered that misinterpretation in that they're talking about the entirety of Mr. Agbajabi's actions. That is the fraud that related to loans 1 and 2, and maybe even loan 0, as is referred to in the briefing. But we believe that that is an expansion of the fraud beyond which is appropriate here, because the district court found that we were not willfully blind as to that fraud. And the only fraud that we were willfully blind as to, according to the district court, which is also an issue in our appeal, was the fraud related specifically to loan number 3. So that is the only fraud.
And can you explain why you weren't willfully blind to the fraud related to loan number 3, since the lawsuit had already, and list pendants had already been filed?
Sure. So it's all a matter of timing. What happened here was that Mr. Agbajabi applied for the loan. My client had all of the loan materials. They ran a title search. That title search happened to come up with a lease pendant on the property. One of the individuals, a Ms. Fakiaglu, reached out to Mr. Agbajabi about that lease pendant. He mentioned that it was something having to do with a personal matter. No mention of this matter or of the allegations that the plaintiff made here. My client then reached out to the title company. They eventually ended up issuing another title report without that lease pendants on the property. So they issued a title that was clean of that. My client received an attorney letter saying that there are no lawsuits against Mr. Agbajabi. So with all of that, with the clean title.
So would your view be that, having received the title insurance and the representation letter from counsel from the borrower, that was sufficient in and of itself to bar a finding of willful blindness?
I believe that that's correct, Your Honor, because, mind you, willful blindness is akin, it's a substitute for knowledge. It's not a finding of recklessness. It's not a finding of negligence. If you look at the language in the Global Tech case, that's the Supreme Court case from 2011, the Supreme Court explains that to find willful blindness, you have to find that the defendant subjectively believes there's a high probability that a fact exists, and then the defendant took deliberate actions to avoid learning of that fact. Those are the two elements. And I believe that when you look at what the defendant here did, it reached out to the title company. It reached out to a lawyer. Those two facts alone will preclude a finding of willful blindness. And we believe that the district court erred in still finding willful blindness in that situation and discounting those facts. I think that what the district court did is it turned the willful blindness standard into a recklessness or a negligence standard, which we believe is inappropriate. So, but let's focus on, let's focus again on the substantial assistance piece, because as the court is aware from our briefing, to find aiding and abetting liability, obviously there has to be proof of the underlying tort, there has to be knowledge or in a substitute willful blindness, and then there has to be substantial assistance in the commission of that wrongful act.
Can I ask you a question on this line? Sorry, I know it's hard on the video, but
no worries.
So I think a little bit about the distinction here between aiding and abetting, which is what we have, and accessory after the fact. And it seems like that sometimes there's some confusion here. And I wondered if you would talk a little bit about like how you see the distinction. I think of aiding and abetting as providing assistance in the commission of the tort, where accessory after the fact is when you're taking actions to help conceal or hide or prevent punishment. And I guess I see a pretty reasonable argument to make. I'm not saying I agree with it, but I see a very reasonable argument about your client being an accessory after the fact. But I have a hard time seeing how they provided substantial assistance in the commission of the fraud itself. Can you help me understand these two distinctions?
Sure. So I think Your Honor has it right, and I think that there is not an accessory after the. First of all, there's no claim for accessory. There's no claim that for accessory after the fact here, and I don't even know that that's a concept.
No, it's a criminal law concept. I
No,
acknowledge,
no.
but this is more of a theoretical distinction that I'm trying to draw. I'm not suggesting that you're criminally responsible under some accessory after the fact statute. I'm just trying to understand the distinction between substantial assistance in the tort and aiding somebody who has already committed the tort, right? And I'm obviously drawing from criminal law principles, but I think the same sense applies here.
I would agree, Your Honor, and it's interesting that the district court actually mentioned that they viewed my client as the getaway driver, I think was the language that they used. Well, what's interesting about that is that kind of plays into that distinction you're trying to make. A getaway driver is there during the commission of the crime, and then assists by helping the perpetrators of the crime leave. And the Supreme Court was clear in the Twitter case that that's exactly what aiding and abetting is. It's helping the commission of the actionable tort. In fact, the Supreme Court said in Twitter, it is thus not enough for a defendant to have given substantial assistance to a transcendent enterprise. A defendant must have aided and abetted by knowingly provided substantial assistance another person in the commission of the actionable wrong. So that's a direct quote from the Twitter case. The Alico case, which is the Maryland Supreme Court case, uses that same kind of language. It talks about for substantial assistance to encourage, incite, aid, and abet the act of the direct perpetrator of an underlying tort. All of the cases in aiding and abetting talk about assisting that underlying tort. And here, that tort was completed years before my client was involved. So,
And why do you've said this a couple times, and I'm not disagreeing with it, but help me understand why you consider the tort here to be the limited to the purchase of the home that's sort of at play here, as opposed to sort of the broader sort of scheme of defrauding this woman of money in a variety of ways.
Because loan number 3 dealt with the issue in loan number 3 was the Mr. Agbajabi's business was given $360,000, and for that my client put a lien on this home. And the fraud that we were accused of with respect to loan number 3, what the district court talked about with respect to loan number 3 is that we were helped. We were the getaway driver in allowing the Mr. Agbajabi to perfect his fraud with respect to the purchase of that house by putting a lien on that house and not allowing the plaintiff to be able to get that house back and cure the fraud. So that was the focus of the district court. It was not.
Was there
the
an argument or evidence that the money that you provided in loan 3, that money was somehow otherwise used by Agbajabi as part of the fraud? So I understand this argument that it sort of provides a wall preventing the recovery.
Yeah.
That doesn't look like a getaway driver to me. That looks like showing up at somebody's house after the bank robbery and saying, how about hold on to this money for me? That's an accessory after the fact. It's not a getaway driver. But was there any argument that the money was actually itself used in furthering the fraud itself, as opposed to merely what I would say avoiding recovery or avoiding punishment in an accessory after the fact sense?
I don't believe so, Your Honor, and here's why. I mean, when you look at the when you look at the timeline, all of the fraud stopped. The last transfer from the plaintiff to Mr. Agbajabi happened in July of 2016, and then they filed a lawsuit for fraud against Mr. Agbajabi in March of 2017. So that I think the date was March 20th or 27th, and I apologize for not having that exact date. In fact, it was March 20th of 2017. And the loan was given March 30th of 2017. So it was given after they had already filed suit on the fraud. So I don't believe that there's any way that that money could have been used to facilitate that fraud. In Your Honors, I noticed that my time is now up.
You've got some rebuttal time,
Yes.
and we'll be glad to hear from you further then.
Thank you, Your Honor.
All right, thank you, Mr. Rosenfeld. Mr. McWilliams?
Good morning, Your Honors. Michael McWilliams and Venable LLP on behalf of Appellee and Cross Appellant Alia Al-Sabah, and may it please the court. Excuse me, I'm fighting off a bit of a cold. Judge Richardson, I'd like to respond directly to your question. I'm at a bit of a disadvantage. You can put everything I know about criminal law in one of those water bottles and still have room for the water. So I'm not addressing it as a matter of a distinction between aiding and abetting and accessory after the fact so much, but simply sticking to whether the lender's activities facilitated the fraud. And there's no doubt that they did. Because up until WBL's arrival on the scene, the money, if you will, was in the ground. The properties had been purchased with that money and improved with that money, and they were there for Ms. Al-Sabah to recover. It was only when WBL arrived on the scene and engaged in these loans in which they ignored all of their underwriting guidelines that matter, and in doing so allowed Mr. Agbajabi to extract the equity from the properties, including the house, which, by the way, was purchased for $470,000, not $360,000. These are big numbers. But what
He got the money out of it, but try to connect up how, and there's this first mortgage lien, but there's a lis pendens filed, so anybody taking that, including the lender, takes it subject to her equitable lien.
That's correct, Your Honor.
All right, so I'm kind of at a loss to find out how you get from there to willful blindness.
Well, I think there are two different issues. Getting the money out is the fraud. It's extracting the money, at which point it disappeared, it's gone, and our only resort
I'm sorry,
Wait
so
a
you're, say that again?
the
Say that one more time. I just want
extraction,
to make sure I understood what you just said. Say it one more time.
the conversion of the hard real estate asset into liquid cash that Mr. Agbajabi then squandered was part of the fraud. That's how he capitalized
Right,
on
but
the
if
effort.
she's got an equitable lien under the lis pendens, then if the bank is wrong, even though it's got title insurance, it's wrong because it's got an attorney representation letter, then it's taken subject to that. Now, they may have to litigate over the priority, but I think to say that it's gone is not correct. If she's got an equitable lien that takes priority over the bank.
And Your Honor, I think that's fundamentally correct, but it doesn't mean she doesn't have damage and she's not a victim of that fraud. She's
Well,
going
she's
to,
got monetary damages,
correct.
right? 7 million. So you had a number of monetary damage claims, went to the jury, got a big verdict. None of that's at issue here. But then you had a separate declaratory judgment action that did not go to the jury. And the district court did not give a declaratory judgment. In fact, it entered judgment in favor of the defendant on that. So under Maryland law at that point, the lis pendens expired and the district court did not give a constructive trust. None of that had anything to do with the bank.
That's correct. But the bank's intervention in facilitating the ability to extract that equity is what completed the damage to Ms. Al-Sabah.
Well, we just may be talking at cross purposes, but if she had, up until that point, an equitable lien that took priority over the bank, I'm at a loss to understand the damages here.
Well, first of all, under Maryland law, Your Honor, it is damage a person has been damaged when they are forced into litigation with a third party. The damages are those litigation costs. And that's what's happened to Ms. Al-Sabah, were she then to contest the lien.
Is that the theory on which these damages? I mean, I haven't heard that. I mean,
No, sir, I'm just responding to Judge
Once you're caught
Agee's.
in a trap, you gotta find some way to get out. But that is, in no part of that has been the theory that I've heard of the district court or the plaintiff in the case, is that the damage here is, I wasn't really hurt, but I then had to go litigate, and that my damage was the cost of litigation.
So you're correct, Judge Richardson. I was responding to Judge Agee's question. We have not advanced that theory. Our theory is that her damage as a result of the aiding and abetting was when the real property was converted into disposable cash that Mr. Agbajabi then squandered as a result of WBL.
And she has a separate judgment for that preceded it in the monetary context that the jury awarded. And it's almost like a double recovery. And I'm just having trouble getting past that, because if she has a valid equitable first lien over the bank with regard to this house, I'm just not seeing how you get there.
It's certainly not a double recovery, Your Honor, in the sense that she's getting her damages twice. And just because she has a judgment against a primary tortfeasor does not mean she can't obtain a judgment against the people who facilitated that tort as a separate tort, and those who are liable for aiding and abetting are, in a sense, liable for the underlying tort damage.
Let's go to the aiding and abetting here.
Yes,
Help
sir.
me understand the willful blindness. I mean, I've closed a few commercial loans back when I worked for a living, and you had two gold standards. You got a title policy and you got an attorney representation letter. The bank got both of these here. I'm having real difficulty understanding what it was they did wrong.
And WBL subjectively knew that both of those representations were fictitious. Mr. Rosenfeld alluded to, and the court asked about, the Liz Pendens and the complaint. WBL had the caption for the complaint. They ran a Google search on it. Ms. Fakioglu's testimony was not.
So they were aware of that. And they
Yes,
went
sir.
to a commercial title insurance company, and the title insurance company decided, we're going to take the risk. We're going to insure this. Why would anybody need to go beyond that?
Because, as Judge Gallagher found, Your Honor, what happened was WBL's COO told the title company to simply remove that Liz Pendens. They didn't do an investigation. In fact,
What difference does that make? I mean, there'll be dozens of loans closed today in this area, and there are going to be negotiations with the title company. It's like nobody in this case ever closed a real estate or commercial loan before. I mean, that just happens every day.
it doesn't happen, Your Honor, in a context in which they remove the Liz Pendens, which is based itself on the existence of the fraud complaint.
And your basis in law to make that representation is?
It's a basis of fact, Your Honor. That's,
Was there any evidence that anybody from appellant actually read the complaint or the Liz Pendens?
there is evidence that Ms. Fakioglu had the Liz Pendens filing in her possession. There is not evidence that she specifically read it. There is evidence that WBL ran a Google search and a Pacer search that found the docket for the underlying fraud suit. So,
Right,
help
but
me
that's not knowing the contents of it.
no, Your Honor, but when you have it and you've been told there's a Liz Pendens based on it, when you decline to even obtain a copy of that fraud complaint and explore what it's about, and instead you just take the word of the alleged fraudster, that's willful blindness. That's sticking your head in the sand.
Help me understand what it is that you think they should have done, right? We live in a world where we have some, understanding that other people have expertise, right? And so we're allowed to rely on other people. And so assume that they had read everything. Why isn't it enough? Maybe you want to say it's negligence. Maybe you think if you're an investor that they're not doing a good job as a steward of their resources. I get that. But how do we get to willful blindness when they go to two different experts and say, listen, in effect, we've got this problem. Are you good with it? And the two experts say, yes, we're good. I guess I'm just having a real hard time. I mean, I think Judge Thacker's right. I'm not sure you got the premise here that they knew. But even if they knew, what is it that you would have had them do? Did they need to get a third expert in order to not be willfully blind?
So, first responding to the expert issue, Your Honor, Judge Gallagher dismissed the bona fides of that attorney opinion letter. It was a form letter from WBL executed the night before.
I mean, that's what 90% of the attorney representation letters will be in a closing. And the attorney that does the representations, they're taking it upon themselves. They're the ones that are liable in case the representations are incorrect. I mean, that's why you get that. And in this case, I mean, they've made all the representations that you would normally expect. After due inquiry, there is no threatened or pending litigation against the borrower that could adversely affect the ability of the borrower. I don't mean to keep beating this, but.
No, let me respond to it directly, Your Honor.
I mean, people do that every day.
They don't do it in the face of a representation to which Your Honor just alluded to, that WBL knew to be false. The representation was, there are no lawsuits.
How did they know it was false? Here
They
you've
had
got-
the lawsuit.
Wait a minute, you've
I
got two
apologize.
professionals.
I apologize.
A title company and an attorney that say the opposite. I mean, what makes the bank the ultimate metaphysical arbiter of truth or falsity here? I mean, I'm just having a real difficult understanding how you get at most past negligence.
I guess I don't understand the concept, Your Honor, that allows them to ignore their own subjective knowledge that the representation with which they have been presented is false. They knew it to be false
I just don't understand how you're saying they knew it to be false.
because they had the docket search, Your Honor, that identified a fraud suit naming Ms. Al-Sabah as the plaintiff and Mr. Agbajabi as the defendant, and it identified that suit as a fraud suit. They had that in their file. And when you talk about willful
But
blindness.
that's a suit, it's not a judgment. There's no proven fraud at that point as concerns the bank in that particular piece of property.
Of course, Your Honor.
If you went on the basis of allegations in every lawsuit, I think commercial transactions would grind to a halt.
I think that's right, Your Honor, but the willful blindness is in consciously electing not to pursue that inquiry. It wasn't that they looked at it.
No, it's to not pursue a third or fourth or fifth expert, right? That's really what you're saying, is that they needed to get a different expert because the two experts in the field weren't good enough. And it's willful blindness to not get a third or fourth. And if they'd had four, you'd just say we needed six.
Your Honor, our contention is not that they needed another expert to take a look at it. Our contention is that presented by what Your Honor identifies and Judge Gallagher took issue with, an expert opinion that there were no lawsuits, they knew that to be false. They didn't need an expert to understand that. What they needed to do was pull down a copy of the complaint. And electing not to do that, electing not to call the counsel of record for the plaintiff on that and explore it, that's willful blindness. That's subjectively and consciously choosing to remain in ignorance.
The opinion didn't just say there were no lawsuits. It said there were no lawsuits that would adversely impact blah, blah, this loan.
Well, Your Honor, that's true. And when they pulled down the complaint, they would have seen that among the allegations were the property that secured their loan, was procured by fraud.
But you don't know if they read it or not.
I only have their testimony that they did not.
Okay.
And I would submit to Your Honor that that is the sine qua non of willful blindness. Knowing that the answer is there for the simple act of pulling down the complaint and choosing not to do that. And all of this, of course, is in the context of what they knew and had substantial concerns about with regard to Mr. Agbajabi. They repeatedly identified him as a high fraud risk. They knew that the people of whom they asked the questions in the sham investigation they did undertake weren't people who could supply anything other than what Mr. Agbajabi had told them. They asked Mr. Agbajabi, they asked his accountant, and they asked his loan broker. All three of those sources collapsed back into just asking Mr. Agbajabi. Their investigation, such as it was a sham. It was a fig leaf. They knew this guy had purchased an
So they
apartment.
had the lawyer, the accountant, and the title companies. Now we got at least 3 experts. And didn't the accountant show them the gift tax returns that were filed way back when?
Yes, Your Honor, and a gift tax return is nothing more than the taxpayer's representation of the same thing he had already told them. To the extent there's expertise,
Filed under penalties of fraud and perjury.
he's an alleged fraudster. I agree with Your Honor. He defrauded her when he took the money that wasn't a gift, and he defrauded the United States government when he declared that it was a gift that, by the way, he was found guilty of that fraud. So we know he's a fraudster. They didn't know it at the time, but had they pulled down the complaint, they would have immediately seen the falsity in the representation to them that there were no lawsuits that could affect title to the property. I see, Your Honor, my time is almost up.
Anything else you
It's
want to
passing.
tell us in closing?
In closing, I think that there is just,
I know, but I'm sorry. Go ahead.
I apologize. In closing, Your Honor, what we've
Oh,
got
that's right.
here
We're doing the
is
cross-bill.
willful blindness with respect to Loan 3 that is so far out on the spectrum, it's virtually actual knowledge. It's one complaint pulled down away from actual knowledge. And just to the left of that is the willful blindness that depends on sticking your head in the sand, and that's what applied to 1 and 2.
You'll be back, so we'll
Thank you,
now
Your
go to Mr. Rosenfeld.
Thank you very much.
Thank you, Your Honor. You're actually, Your Honors. And I'll keep this brief because I think that the court is focusing on the right aspect of willful blindness. Because there was no, as counsel for the plaintiff admitted, there was no testimony stating that my client, WBL, actually read or knew the contents of the lease pendants or the lawsuit. The only evidence was that it happened to be in their file. And
And I guess
the bottom
opposing
line-
counsel would say that you were, or appellant was willfully blind for not reading what they had in front of them.
Well, there's no evidence, by the way, that it was in front of them and they didn't read it. There's evidence that it was downloaded into the file by someone. And what the testimony was is that because of the fact that by the time the senior executives made the loan decision, the title company had already insured over it. They already had the attorney letter. He felt no need to go any further. Should he have? Maybe. Does he wish he had? Probably. But that is more negligence. That is more, should your guidelines be better? Should your practices be better? What it is not is willful blindness, because willful blindness is taking deliberate action to avoid learning of a fact. Here, they took the deliberate action. They didn't do nothing. They went to the title company. They went to an attorney. Both of them passed over it, and then they felt comfortable. They did not go further. So, with that, I think that the finding of willful blindness in this case, it's just it was clear error. And for the same reason, we have not touched on the issues of the cross appeal, which I'll try to do in the next couple minutes. But for the same reason that there wasn't willful blindness with loan 3, there clearly wasn't willful blindness with respect to loans 1 and 2. I think Judge Agee mentioned the accountant. My client, when it learned of the large wire transfers, not only went and asked, they didn't do nothing. They didn't, affirmatively try to avoid learning about it. They not only went to the borrower, Mr. Agbajabi, but they went to his accountant. And the accountant testified that he gave him the gift tax returns, which were filed under penalty of perjury with the government. He also told my client that he met the plaintiff. He testified that he met the princess, believe it or not, and she is a legitimate princess, and that she made these transfers. So I don't know how, with that record, with asking for documents, with talking with the borrower, with going to one of the borrower's professionals who filed the tax returns and asking him about this, how that is even close to willful blindness. And when you look at, there are two other aspects to the cross appeal. One is there's a $150,000 transfer that was made. It was the final transfer. It was made in July of 2016 after the plaintiff admitted that she was that she was alerted to some potential concerns, that she had told Mr. Agbajabi no more until he gave her documentation. He had not given her documentation. She then gets a call from his wife saying that they're going to lose their home, unless she sends even more money.
And she did it
admitted-
anyway.
Yeah,
And she sent it, so she was the one who was willfully blind
She was the one, well,
in that
I
instance.
don't know if it's that concept, but certainly she couldn't justifiably rely on his representations at that point in time. So there was no underlying fraud. So you can't aid and abet when there's no underlying fraud. With that, I see my time is up. Thank you very much, Your Honors. I appreciate the opportunity.
All right, thank you, Mr. Rosenfeld. Mr. McWilliams?
Thank you, Your Honor.
You want to tell us something about your cross appeal while you can?
I do. Picking up on the thread of the question Judge Thacker asked about the lawsuit that was in front of them, I submit to Your Honors that, this is still on loan 3, but it is an important point. Electing not to pull down a copy of the complaint is the epitome of willful blindness. It's right
You
there.
agree they didn't have the complaint in the file. There's been some discussions that there's a little ambiguity here. They had the Liz Pendens in the file, but not the complaint.
The Liz Pendens itself had a copy of the complaint, Your Honor, so I think that point is not entirely clear. It's an open question.
So maybe I'll rephrase it, because it seems like you are trying to, in the record, what is the best evidence that the file included in some way or another the actual complaint, as
I can't-
opposed to a copy of the Liz Pendens without the complaint? Because I thought the record showed there was a copy of the Liz Pendens, but there was no evidence that showed that the complaint itself was in the file.
Just one moment, Your Honor, I apologize. I just want to take a look real quick. I think it's. Your Honor, if I may, let me return to that if I don't run out of time.
Yep.
I think there is absolutely clear evidence that they had the copy of the Pacer docket search. I'm less certain as to whether the
Okay.
complaint itself
That's fine.
existed in
But
the
the
file.
Pacer docket search is not of the complaint, it's just lists that there is a filing.
It's exactly what you see when you get that
Right.
first page, Your Honor, with counsel and the nature of the claim, et cetera, the first page of an ECF printout. There's been discussion of the accountant as an expert, and Mr. Rosenfeld referred to what the accountant told WBL when they asked him. And what Mr. Rosenfeld said was the accountant described her as a legitimate princess and B, the actual transfers occurred. Neither of those are the question. Their concern was, are these actually gifts? Agbajabi had told them that these multi-million-dollar sums from somebody not a family member from outside the U.S. were gifts. On its face, that representation cries out for an investigation that can get to the answer to the question, are they gifts? They didn't even ask him that question. They said, did you prepare and file the 3520s? And he said yes. And if they had asked him if that means they're
If
gifts.
he had known it to be false, he could not have filed them, right?
No, sir, but yes, sir, that's correct. But he
If he
did
had-
not
if
know
he-
them to be true. All he's representing is that my client, my taxpayer, has represented this to me. It collapses back to
course.
Mr. Agbajabi, the very statement they should be investigating. Compare that to what would
Did they
happen.
need to hire an FBI? I say maybe that's the line. That's the expert that you think they needed, was like a retired FBI agent to like unravel the fraud.
Not at all, Your
Like
Honor.
they needed, what is it that you think they should have done? I mean, I guess I'm still struggling a little bit. You know, the guy says it's a gift. I go to the accountant. There's a gift tax return. Like, put him on a polygraph? Like, hire an FBI agent? Like, what is it that you think they should have done in the gift tax context?
Either of two things, Your Honor. Recall that one of the representations that the accountant told them was the apartment was purchased as a residence for the daughter of the woman who supplied the money for the purchase. At that point, WBL has two clear options. They can A, ask the daughter if this gift story is true, or B, ask to be put in touch with Ms. Al-Sabah and ask her. It doesn't require an FBI agent. It doesn't require a polygraph. It requires going to the source of the alleged gift and saying, is this true? Had they done that, had they not stuck their head in the sand on that one crucial thing, none of this would have resulted in anywhere near the damage
It
that Ms.
seems like the
Al-Sabah suffered.
linchpin for your argument, both on all three of the loans, is you can't trust the professional title insurance company, you can't trust the professional lawyer, you can't trust the professional accountant. And that just seems like a bizarre position to take.
I don't think it's, I respect Your Honor's view. I don't think it's bizarre to take it when you have knowledge, actual knowledge that those representations are not true. You can't simply.
Actual knowledge that the gift tax representation, that the gift representation was not true. Like, what is the possible actual knowledge? What is the actual knowledge that they had that this was not a gift?
They knew that it had been purchased as a home for her. That is fundamentally, for the daughter, that is fundamentally inconsistent with the idea that it's been gifted to him. They knew that.
And from that, they had, at your argument, all right, that's helpful. To the extent your argument turns on that, that's a like helpful framing. I
think-
appreciate that.
I see I'm past my time. If I could, Judge
ahead,
Richardson,
go
I
ahead.
would say, yes, that's helpful, but that's nowhere near the significance of them simply sticking their head in the sand in the face of this information, that all they had to do was ask the person who could give them a definitive answer. No FBI, no polygraph, no additional experts. Pick up the phone or send an email and ask the purported giver of the gift, was it a gift? Thank you so
All
much
right,
for your
thank you,
patience and
Mr.
time.
McWilliams.
Thank you, sir.
We're gonna come down and greet you and send our remote greetings to Mr. Rosenfeld. Ricky, I see that we have another attorney appearing by video on the next case. Do you need any time to switch that out? Nope. Okay, then we'll move on to our next case after this. Mr. Ping, you're going to introduce our student counsel today.
Yes, good morning, Your Honors. May it please the court, John Pang with the Georgetown University Law Center's Appellate Litigation Clinic. With the court's permission, third-year law student Jennifer Campos will present arguments on behalf of the petitioner.
All right, thank you very much. Ms. Campos, we're glad to hear from you when you're ready.
Okay. Good morning, Your Honors, and may it please the court. Ms. Montesinos Cisneros is eligible for cancellation of removal because she complies with all three requirements of Section 1229BA, including the requirement that she establish 7 years of continuous residence after having been admitted in any status. In 1994, Ms. Montesinos Cisneros was admitted in any status at Dulles Airport. Ms. Montesinos was admitted when she presented herself for inspection to an immigration official at the airport. That immigration
So
official.
tell us why you say she was admitted as opposed to paroled.
Your Honor, she was admitted because she presented herself. An admission is a lawful entry after inspection and authorization to enter by an immigration official. And in this case, Ms. Montesinos presented herself, and the immigration official communicated to Ms. Montesinos that she had been admitted through the admitted stamp in her passport, as opposed to being paroled into the
So
country.
is that stamp what you say differentiates her from a parolee?
Yes, Your Honor, because it is what the immigration official communicated to the applicant to admission. And we look to the actions of the immigration official to determine what a person's entry designation is.
Who are we judging that based on, right? So, I mean, I take you to be saying there that, like, this is the sort of commutative content of what was done, and that somebody reading that piece of paper and the information on that piece of paper would have understood that to be an admission rather than a parole. Is that like an objective inquiry? Is this sort of like a statutory question? Like, what do we think the public would have understood? Is it like specific to your client? Who do you think we should judge that? Because there's some ambiguity about what that meant, right? Because it has two conflicting ideas. It says admission, but it says DED, which is obviously not admission. And so can you help me understand who's the sort of audience that we're trying to think of, the commutative content being given to?
Your Honor, BIA cases like Matter of Quilantan and Matter of Arreguin tell us that we focus on what the immigration official communicates to the applicant for admission. And so in this case, through the admitted stamp.
Even if they're wrong?
We don't believe the immigration official here was
I know.
wrong, Your Honor.
What happens if the immigration official makes a mistake?
Your Honor, it depends on the situation. In this case, because Ms. Montesinos presented herself, showed all her documents, and the immigration official had the opportunity to inspect them and then authorize her admission into the United States.
And the immigration official has discretion in what to do at that point, right? Admitted isn't the only stamp the immigration official has.
Yes, Your Honor. The immigration official could choose to deny them entrance, parole them, but in this case, the immigration official chose to admit Ms. Montesinos into the United States.
The immigration official did not exercise his or her discretion to parole. They stamped admitted, correct?
Exactly, Your Honor. An admission only requires.
Well, what
Sorry,
if
Your
if she could only be a parolee? Because she was only here under this deferred action classification, and when she was admitted, it was DED until December 30, 1994. Why doesn't that translate into a parole status?
Your Honor, kind of 2 points on this. The first one being that the notation, the DED notation underneath, they're kind of speaking to two separate issues. So admission and status are two separate concepts in immigration law. And so the admitted portion of the stamp is communicating to Ms. Montesinos that she was admitted, that was her entry designation, as opposed to parole. Whereas the DED notation underneath is communicating to Ms. Montesinos, this is a status that you have when you're in the United States. And so they're two separate things in that way.
Well, would you agree if we found that she was a parolee and not admitted, then she can't qualify?
If your honors were to find that she was not admitted, this on December of 1994, yes, your honors. But Ms.
Can you go back to the question that I believe Judge Agee asked, or I understood you to sort of answer? Of what happens in the scenario where there's, obviously this is not this case, right? So accept it as hypothetical, where there's complete fraud. So somebody shows up at the border and it's at fraud all the way down. And the guy doesn't, the person doing the collection doesn't catch it and stamps admitted and the person comes in. Is your view that is an admission? And if so, sort of in answering that, I understand that person would have offered themselves for inspection, but the statute doesn't just limit it to offers for inspection, right? It also says that they have a lawful entry. And so it seems like in that instance, the fraud would mean that it's not a lawful entry, even though there's an admitted stamp on there. In that hypothetical, it's not your case, I understand. Would that be an admission merely because there's the stamp that's there, even if all the documents to get that stamp were indeed fraudulent?
Your Honor, if that fraud were in the form of a person passing themselves off to be a U.S. citizen, then that would be a procedurally irregular admission, and so in that case, it would not be a proper admission. And I guess the word lawful in this statute is telling us that it has to be procedurally regular. A person has to present themselves, make no false claims to U.S. citizenship, has to be inspected, and then if...
So where do we get the procedural regularity as that being the only meaning of lawful? So I understand one example that would not be a lawful entry is one that's a procedurally irregular
Yes,
entry.
Your Honor.
So that's, I take that's your answer to the fraud example. Why do you limit the word lawful entry in that context to procedural irregularity, right? So that doesn't say that, right? It says lawful. So why are you equating those two?
Your Honor, in cases like matter of Quilantan from the BIA, Tula Rubio, Saldivar, all these cases, those are from the 5th and the 9th circuits.
Maybe let's start with like a statute rather than a BIA decision that I can't give deference to anymore, or another circuit that's not binding. Like why when I read the words in the statute, and one of the challenges is we've been deferring to the BIA, we don't do that anymore. We now have to look at like what statutes actually mean. Mm-hmm. And lawful entry, to me, certainly includes this procedural irregularity point that you've agreed to here, but I don't understand why it's so limited.
Your Honor, admitted has kind of been interpreted to only require procedural regularity. There is no substantive legal requirement to the definition of admitted.
But isn't that odd? Because the statute has two different parts, right? It says admitted means, and then it has two things. One is that there's a lawful entry, and two is that they do so procedurally regular after inspection and evaluation, or whatever the precise language is. But the procedural piece is actually the second clause of the sentence. Like lawful entry is a distinct requirement in the statute. And if you read lawful entry to just mean the procedural piece, then you've just read it out of the statute. It no longer is part of the statute. And so I guess I have a hard time understanding why I should read lawful entry to mean the second clause when it's a standalone clause. And then I don't know what lawful entry means if I'm just saying you just have to present yourself. Do you understand my consternation? I'm
Yes,
just trying
Your
to,
Honor.
I literally am just trying to figure out what this thing means.
Yes, Your Honor. I guess the focus here is on what the word after is doing. So it's telling us that in order for a lawful entry to be effectuated, the person has to present themselves for inspection and be authorized to enter the United States.
No, but then you wouldn't use the word lawful, right? Because then you would just say, when you have an entry after the procedural piece, right? So the lawful has to do some other work other than just the procedure that follows at the end of the statute, right? Because otherwise it's just repetitive, so that wouldn't make sense. So if you just wanted it to be the procedural piece, if all that was required for admission was entry following proper procedure, right, you wouldn't use the word lawful. Lawful has to mean something more than just the proper procedure. Otherwise, the statute doesn't make sense. A lawful entry after these things means that after is not the only thing, it also has to be lawful.
Your Honor, the fact that it follows that it's lawful entry after inspection and authorization, I believe still means that it has to just be procedural regularity, and it's kind of in distinction to all unlawful entries, which is
minute-
when a person completely evades inspection.
A
My
minute ago,
apologies.
I think you were going to talk about the Fifth Circuit case, the Tulu Rubio.
Yes, ma'am.
And since the Fifth Circuit does so many immigration cases, I would like to hear what you had to say about that opinion.
Yes, Your Honor. So in that case, that was the case of a wave-through admission. And so that person showed up to a port of entry, had no kinds of documents entitling them to enter, well, just to entry documents, but the immigration official communicated to them through a wave-through that they had been admitted. And so in that case, the court found that that person had been admitted and in any status, because in any status was written so broadly that it encompassed kind of any and all statuses.
And just waving them through counted as admitted for the Fifth Circuit, correct?
Yes, Your Honor.
Where here you have an actual stamp, the words admitted. So to me, that seems like you have a stronger argument than the Fifth Circuit found in Tulia.
Certainly, Your Honor. One could argue that this is even more procedurally regular because she walked up to the immigration official at the airport, presented her documents, the immigration official inspected her, and then stamped her.
And the
and
person
admitted
in
to her.
question in that Fifth Circuit case wasn't even the driver of the vehicle, right? They were a passenger.
That's correct, Your Honor. The driver was a U.S. citizen, but the person themselves was simply a passenger with no documents to enter the United States. Yes. So kind of speaking to the issue of status, Ms. Montesinos had DED status at the time that she was admitted. Status itself is not defined anywhere in the INA, but we know that dictionaries define it as a person's legal condition. And because of the phrasing in this subsection, status is, any status is so broad that certainly Ms. Montesinos' non-priority DED status would qualify under this as well.
But under your reading, anything qualifies as status.
Yes, Your Honor. And that is
Which
also
would seem
how.
an odd way to write the statute if there are no constraints.
Your Honor, that is the way that Congress wrote it. But that.
If you probably didn't fly up here because you're from Georgetown, but, if you get on an airline and they say, like, if you have any status, you can board now, right? The answer of, like, I've never flown is not, like, an answer that gets you, like, boarding. Like, any status, like, has, like, communicative content that is not encompassing no status.
Your Honor, DED is a form of status.
But those are two different arguments. So I understand that argument, that you think DED is a status, and I very much understand that argument. I thought you were suggesting to Judge Agee that it also includes, like, no status. So someone who arrived here illegally with no inspection, that person has a status in the vague sense of the word, right? They're here illegally, right? And I understand you to sort of be making both of these arguments. One, that it's so broad that whether DED is itself a status doesn't matter because any status, including no status, is encompassed. And then you separately make the argument that DED is, as a term of art, a status. I understand the second one, but the first one seems like a really hard argument, right? Which is that even illegal or no status qualifies as any status.
Your Honor, the INA, in the INA, Congress included things like unlawful status. And so even people who come here illegally to the United States, those people still have a status. It's unlawful status. And so that is why
So is there anybody who would not have a status?
No, Your Honor. No, because the phrasing is so broad. In other sections.
And that's what the Fifth and the Ninth Circuit have both found?
They read it to be as broad as we're arguing here today, Your Honor.
Are there any circuits that have read it otherwise?
Not that we could find, Your Honors, as far as I'm concerned. But yes, I mean, it's phrased very broadly. In other sections of the INA, when Congress wants to specify lawful or unlawful status, it does so, and the fact that here they chose to use such broad language as any status tells us, kind of communicates what Congress intended in this subsection.
Because Congress knows how to use the word legal when it wants to, that Judge Richardson was asking you all about legal entry earlier.
Yes, Your Honor. When Congress wants to specify that, it does so, and the fact that it didn't here tells us what Congress wanted here. If Your Honors have no further questions, I'm happy to.
You've got some rebuttal time.
Yes, thank you, Your Honors.
Okay, well,
What happened to him?
we lost our lawyer.
Sorry, I just had to unmute myself, Your Honor.
Okay, Mr. Robbins will tell us what the government thinks.
Okay. Jonathan Robbins here on behalf of the Attorney General, Your Honors. Thank you for accommodating the remote argument in light of the lapse of appropriations.
We're very familiar
after-
with the lapse of appropriations.
Yes. As you've just discussed with my colleague on the opposite side of the podium, the key question in this case pertains to whether the agency correctly found that the petitioner failed to establish the requisite continuous residence such that she would be eligible for cancellation of removal. And of course, the government contends that she was not admitted in any status until November of 2006, when she adjusted her status to that of a lawful permanent resident under NACARA. Now, of course, the petitioner is contending.
Is there a threshold question here before we would get to status that the alien is either admitted or paroled, which makes a distinction? And if we were to conclude the alien was paroled, we would not deal with the status question.
That's correct, right? The statute says admitted in any status. So the first part would have to be an admission.
All right, so tell us what the
And a
government
parole
says
is not an.
on why she was admitted or paroled.
Sure. So, well, we start with what the facts of the case are. The petitioner applied for advanced parole. She concedes that in her opening brief. She also concedes that she used the advanced parole, and that is consistent with the evidence that we have in the record, which shows that the immigration officer specifically wrote DED into the stamp. Now, Your Honor's asked a question
Into the
about.
stamp that said admitted at the officer's discretion. Could the officer have stamped it paroled?
Well, I don't know exactly what stamp the officers had at the time. That's not clear. But the immigration judge did make a factual finding in this case that it appears to have been a mistake to use the admitted stamp by the immigration officer. Now, of course, factual findings are reviewed by this court for substantial evidence. So in order to overturn that factual finding by the immigration judge, the court would have to find evidence so compelling or so overwhelming that no reasonable fact finder could have found as the immigration judge did. But I think the immigration judge reached the
But
reasonable
haven't
conclusion
we
here.
held that admission does not require any specific visa or status in that Mauricio Vasquez opinion?
Not in the context of this statute. So there's a big.
But so the
conflation.
answer is yes, we have. We did
I wanna
make that
clarify.
holding, right?
Not with respect to cancellation of removal. So
Why does that matter?
Because the language in the statute is different. So a lot of the talk of the petitioner is bringing up, it has to do with procedural regularity in the context of admission for the purpose of adjustment of status. That statute does not use the term that the cancellation statute uses. That just uses the term admission. And the board in its case law pertaining to procedural regularity and whether that constitutes an admission in cases where there are sort of wave-throughs and where it's held that that's an admission, that's where admission is a term by itself in the statute. That's not what we have here. The term we have here is admitted in any status, and that's an important distinction. So the petitioner is trying to graft on a whole different body of case law that pertains to a different statute to this statute, which has different language. And getting back to Your Honor's question, I know you asked a question of my colleagues in the opening presentation about the immigration officer's discretion. The immigration officer does not have discretion to admit people who are inadmissible. So we know from the stamp, because he wrote DED, that he knew why they were coming in. DED does not entitle somebody to be admitted to the country. Without that advance parole document, the petitioners would not have had valid travel documentation, and that would have rendered them inadmissible to the United States. This is one of the points that the board has made in matter of Castillo and Gulo, and that the dissent made in the Ninth Circuit's decision in Saldivar versus Sessions. This notion that you
What
can
about
be
the
admitted.
Fifth Circuit? What would you do with the Fifth Circuit case, with the wave-through case?
Again, the wave-through cases have to do with adjustment of status. That's a different statute. It's not the cancellation of removal statute, which has different language. That's the language admission in the adjustment context versus admitted in any status in the cancellation context. I would also point out that the Fifth Circuit case didn't have a situation where the individual was paroled into the United States. And that's very important because the statute could not be more clear. It
So
says parole
admitted
sh-
meant admitted in the Fifth Circuit case, but admitted doesn't mean admitted here.
The adjustment of status contact has different problems with regard to admission than does the cancellation. But the fact that the statutes use different terms is important. That's one of the things that the board pointed out in matter of Castillo and Gulo when it refuted the reasoning of the Fifth Circuit and said, even though it would adhere to that in the Fifth Circuit, it was not going to follow that reasoning in all the other circuits where that was not binding. And look, Your Honors, I understand that whenever a sister circuit issues a particular decision, and in this case there are two, although there's a very compelling dissent in one of them.
And particularly the
But-
Fifth Circuit in an immigration case.
Right, well, they were both immigration cases. That's the nature of what
I
happens
know,
with
but the
admission.
yes, the Fifth and the Ninth Circuit do a lot of immigration cases.
They do. But there's a very compelling dissent, and I would argue that the dissent in the Ninth Circuit case in Saldivar is far more compelling because it points out that the Fifth Circuit bought a specious argument. And the specious argument that they bought was that this cancellation statute has two provisions. It has provision 1 and provision 2. Provision 1 says, it refers to an alien lawfully admitted for permanent residence. And then the second provision says admitted in any status. And so the reasoning that the Fifth Circuit and Ninth Circuit pointed out was it says, well, that first provision says lawfully admitted, and then the second provision just says admitted in any status. So we interpret that to mean that Congress knew how to use the term lawful. But the board and the dissent in the Ninth Circuit pointed out that that's not correct. The court was only looking at part of the statute. It says lawfully admitted for permanent residence. Lawful permanent residence is a term of art. So the term lawful there, it has to do with the permanent residence. And admission for lawful permanent residence is not something that occurs at the border. That's something that occurs after you've come through the border. You adjust your status, right? Admission is something different. That's referring to your entry at the border. And so the board and the dissent in Saldivar pointed out that that was a mistake made by the majority in Saldivar and the Fifth Circuit in Tula Rubio. So while I understand that the court shouldn't create a split, or shouldn't do that if it can avoid it, sometimes there's a good reason to. And there's a very compelling dissent in the Ninth Circuit decision that really points out that the interpretation of the statute that the petitioners are providing here today, it doesn't comply with the language of the statute. It really defies common sense. It creates all sorts of perverse problems with the statute that defy what Congress could have possibly intended. And again, this case presents a particular fact that was not
So
present.
your strongest legal support for your argument is what, the dissent in the Fifth Circuit case?
No, it's the dissent in the Ninth Circuit case, Kaczynski's dissents in Saldivar, and the board's decision in matter of Castillo and Gulo, which really explained why the Ninth Circuit and the Fifth Circuit had really reached a conclusion that didn't make any sense. So,
All
for
right, so
example,
your strongest
I'll-
argument is the dissent in the Ninth Circuit case.
Yes, and the board as well. The board has pretty solid reasoning. A lot of it mirrors the dissent in the Ninth Circuit case.
Can
but
you
you can
help
take
me-
a bit. And look,
Counsel?
even if, yes.
Can
Yes.
you help me understand? I asked your colleague a little bit about the question, the fraud example, and whether someone who shows up with fraudulent documents and gets admitted, stamped admitted, or written admitted, whatever it is, based on those fraudulent documents, is that person admitted under the statute, in your view? When we look at the statute of admitted means lawful entry after inspection, and are they admitted? Like if a year later, the question is, was this person admitted based on those fraudulent documents? Are they admitted, and if so, why not? Why or why not?
Under the cancellation of removal statute, no, because it says admitted in any status. And any status really has to mean some
Okay,
type
all
of
right, so
lawlessness.
I understand that argument, but back me up just to the admitted piece. So I'm just trying to understand how you understand this statute that says admitted means lawful entry after inspection. And so if somebody shows up with fraudulent documents and gets admitted, forget the status piece, or imagine that the admission like includes a status, mistakenly or not, whatever. But it's fraud that gets them there. In your view, is that a lawful entry after inspection, or not? And just help me understand how I ought to think about that statute.
I would say not, because the statute specifically provides that certain types of fraud render an alien inadmissible. So there are specific provisions of the INA that set forth that they are not admissible, very clearly.
Okay,
I don't remember
but the question,
specific
all right,
provisions.
so, but how do I fit that under the statute? So that's what I'm trying to get at, right? So this, because in that instance, they are inadmissible, right? But, you know, we're hypothesizing here that the officer made a mistake. The officer didn't catch the fraud, right? Just wasn't good enough to see the counterfeit or whatever it was. It doesn't matter. They made a mistake. And so they wrote on the piece of paper, admitted, and gave them a status, whatever it is, given the fraud that had existed. And what I'm trying to figure out is whether a year later, when it matters for some immigration reason, whether that person was admitted on that day or not.
I think the government would argue in court there that the entry was procedurally irregular due to the fraud and that it wouldn't constitute an admission. But again, I want to be very clear. The procedural regularity of an entry with respect to the adjustment of status cases is not pertinent to this case with cancellation of removal. The term here is more than just admission. It's admitted in any status.
Yeah, I
But
understand that distinction, but they both have
Yeah, but-
admission, and then the status piece is unique here. I totally understand the status piece is a separate argument. I'm just trying to understand the admission piece. And your argument is limited to procedural irregularity?
Right,
with
the cases
respect to
that
what
the board
admission
talks
means?
about-
Go ahead.
Oh, I'm sorry. Well, so matter of quintillan, those are the cases where there's a wave through, because obviously a lot of times at the border, what will happen is there'll be a long line of cars and the immigration officers will just sometimes wave people through. And there was a question in the law pertaining to adjustment of status as to whether that was an admission, because in order to apply for adjustment of status, you have to show that you're admitted. And so the board has held that the procedural regular entry, when you're just waved through for adjustment of status, which only uses the term admission, that can be procedurally irregular. Now, if there's a situation of fraud where they present a false document to the officer in that situation and it's not just merely a wave through, the government would argue that that's procedurally irregular and that shouldn't constitute an admission and that somebody shouldn't benefit from their fraud to the immigration officer. So, but there are situations, I mean, you could argue that wave throughs can be errors, right? Sometimes people are waved through who probably shouldn't be admitted to the United States. They may be admissible for any number of different reasons. But again, that is in a context of a statute pertaining to adjustment of status that only uses the term admission. And the board has limited its discussion about whether a wave through is an admission only to that statute. It has not extended that sort of.
That discussion, that's the same discussion that you talked to Judge Thacker about with respect to the 5th and the 9th, and the BIA's decision thereafter. That's that same discussion.
Exactly. And this is not the discussion in this case for several reasons. Look, even if you bought the reasoning, which is specious reasoning, of the majority in the 9th and the 5th Circuit, that's not relevant here. Neither of those cases had to do with an individual who was paroled into the United States.
But you're
I mean,
asking
plain
me to
language-
buy the reasoning, or us to buy the reasoning that admitted does not mean admitted.
Well, parole definitely doesn't mean admitted. The
Right,
statute
and
could not be more clear about that.
the immigration officer could have stamped paroled, but the stamp
yes.
is admitted.
Well, again, I don't know exactly what stamps were available to the immigration officer, but it's clear that the immigration officer wrote, handwritten into the stamp, DED. And DED does not entitle an individual to be admitted.
Immigration officer have written paroled? let's assume they didn't have a stamp, which I suspect they have a stamp. But let's
they do. They
assume they
certainly do after
didn't,
the fact. That's in the
and could they have written it? Could they have written paroled, or is that too many letters, so they just wrote DED?
They wrote DED, but it's important to understand what that means. DED does not.
Could they have
entitle an
written
individual-
paroled? Could they have written paroled?
It's possible, sure.
But they didn't.
But they didn't. So we're left with what the immigration judge made as a finding of fact. The immigration judge looked at the evidence. He saw this handwritten notation of DED and says, I think that the use of the stamp with the affixed term of admitted was simply a mistake, because it's clear that the immigration officer understood.
It's not
that this
clear.
person was
He's.
I'm sorry, yes?
The immigration judge, you're saying, made a finding of fact that using the stamp, in this case admitted with the DED, that was erroneous?
No, well, that using the affixed term admitted in the stamp, that appears to have been a mistake. But that it's clear that the immigration officer understood the basis for entry. Remember, the petitioner is
What
not
part was
admissible-
the mistake? Stamping admitted?
Yes.
So what,
Because that's
what should the immigration officer have done, in your view?
The immigration officer did exactly what he should have done. He made a notation, handwritten, within the stamp, that indicated what the actual reason for entry was, which was DED. And the only way that the petitioner could have re-entered under DED is by parole. And that's consistent with the fact that she admits that she applied for advanced parole. She admits in her brief that she used the advanced parole document.
All right, so what's the
That's
effect?
on page 5 of her brief.
Okay, so what's the effect, in your view, of the immigration judge's finding as to the incorrectness of using the admitted designation? How does that affect the resolution of this case?
Okay, well, in order for the court to say that the immigration judge got that wrong, it would have to overturn that finding of fact. The only way the court can do that is by finding that the record compels a contrary conclusion. But the record doesn't compel a contrary conclusion here, because there's a handwritten notation that shows that the immigration officer understood why this person was being allowed entry to the United States. Because the officer wrote DED, it's evident from the record, or at least a reasonable mind could conclude, that the immigration officer was admitting the person under the advanced parole document, which they concede they used to re-enter the country. And so, because it's parole, I mean, the statute is clear. Parole shall not be regarded as an admission. Plain language does not get any plainer than that. And because that is the factual finding of this case, and petitioners never disputed that factual finding, they concede in their brief that they used this document. They now, in their reply brief, have sort of belatedly tried to suggest, well, maybe we didn't use it, or maybe we didn't. But that's not what the facts of the case are as established in this record.
All right, now that you've talked about why admitted doesn't mean admitted, do you also want to get to your argument about why any doesn't mean any?
Well, any status doesn't mean status and no status. That is, frankly, Your Honor, I think the dissent has pointed out that's something of a silly argument.
What
That
dissent?
Totally writes
What
status out of
dissent? Did you
I'm
say
sorry,
the
what?
dissent, you think the dissent has pointed out? What dissent?
The dissent in Saldivar, Kaczynski's dissent in
You're back to the
Saldivar.
Ninth Circuit dissent. That's the weight of your authority for your argument, is a dissent in a Ninth Circuit opinion. And the BIA. And,
Well, there's only two opinions on the matter.
all right, well,
and
what does, how is it that any doesn't mean any?
It's not that any doesn't mean any. It's the term is any status. so
Right, and the
question
term is
what-
not any legal status. It's any status.
Right, but no status isn't status, and that's the point.
What did you just say? No status
No
isn't
status
status.
does not constitute
Oh,
any
okay.
status. Saying that somebody doesn't have any status, look, why would Congress mention status at all if you could show either some status or no status? That doesn't make any sense. They would have just stopped at the word admitted, right? They could have just said, you're eligible if you're admitted. But by saying admitted in any status, they must want to cut off at least some people. I mean, 100% of the people either fall into the category of legal status or illegal status, or status or no status. That covers 100% of the people. So why would Congress have mentioned status at all if it included both? That makes no sense. And that's why we're relying on the dissent. The dissent points that out and said this doesn't make any sense. And why would Congress want to treat people differently? For example, suppose you defrauded somebody at the border and acquired an entry that way. Why would Congress want to give a benefit to those people over somebody who just simply jumped the border? Right? That wouldn't make any sense. It creates perverse incentives. The Ninth Circuit talked about how it creates perverse incentives to lie. When somebody's waved through at the border, that's not something that's documented. So it gives an incentive for anybody to just claim that they were waved through and they're going to be eligible for relief. That couldn't possibly be what Congress has intended. And that's and again, it's not just the Ninth Circuit. That has to do with respect to the any status. But there's also a Third Circuit case that's almost on all fours with this case of an individual who, like petitioner, applied for advanced parole, entered the country on parole, and was in DED, was eligible under the criteria established under the Deferred Entry Departure Memorandum, just as petitioner here. And the Third Circuit said that's not an admission. And the Third Circuit's case is by far the one that's the most on all fours with this case. The facts of that case are almost identical, with the small exception of the mistake with respect to the stamp.
Is that the Xing case?
Yes, Zeng.
Zing.
And I would also point out that
there wasn't any argument there that he'd been admitted when he returned after being granted advanced parole, correct?
Right. This case is a
So
little
it's
bit
not
tricky.
identical to this case.
Well, like I said, Your Honor, it's not identical with respect to the mistaken stamp. But again, that's a
It's
factual finding
identical.
of the IJ.
It's not identical with respect to the issue we're talking about,
Well, it's
which is the
identical-
mistaken stamp, or the alleged
the
mistaken
petitioner
stamp.
There was less dispute about what the nature of the advanced parole. But our point is here, it's not, I agree it's trickier to determine in this case that the petitioner was admitted or allowed entry to the country, not admitted, sorry, allowed entry to the country based on her application for advanced parole. That's the only way you can get back in under DED. She's not admissible to the country without that advanced parole because she has no other status to be. If she had left under DED without applying for advanced parole, the immigration officer wouldn't have let her back in. She wouldn't have been admissible to the United States. So that's why the immigration judge made the only conclusion that he could make in this case, which is that because we have this notation that shows that the officer knew that this was DED, this could only have been an entry allowed by parole, not by admission.
Can I ask a question, and you can say that you don't know the answer to this, because it's not, like, totally on board, but can a petitioner in some other case, maybe not this one, or maybe this one, argue estoppel? Is estoppel an argument that's available? So one of the things that just strikes me as like a little bit odd, right, is that the mistake here of putting admitted, you might imagine a world in which like a petitioner could argue estoppel, that they relied upon that in some way. I'm not sure that works here, but is that a plausible line of argument, or is that just something you're not familiar with?
I haven't seen estoppel arguments pertaining to mistakes made at the border by an immigration officer. I mean, it usually comes up in the context. I don't think I've seen an estoppel saying that the government is stopped from making an argument because of a mistake that an immigration officer made. That I haven't seen. It usually just arises in the context like it arises in this case, where they say, well, that particular mistake has some sort of legal significance one way or the other. I haven't seen it in the context of estoppel.
Okay.
Does that take care of you?
Yeah.
But I don't.
Thank you,
I see
Mr.
that I'm.
Thank you, Mr. Robbins. We appreciate your argument, but your time has expired, and we've given you a little extra.
Thank you so much for your time, Your Honors, and again, thank you for accommodating the government in the remote argument.
Certainly.
Thank you.
Okay, Ms. Campos, you've got some rebuttal time. So let me ask you at the beginning, based on something opposing counsel has represented, that the immigration judge made a factual finding that use of the admitted stamp was erroneous. So have you challenged that finding anywhere?
Your Honor, we have not, because that was not a finding that the immigration judge made.
Okay,
There
and
was
tell
no
us
finding
why
of
you,
fact.
I'm looking at the top of JA 90, so tell me why that's so.
Your Honor, I don't have the appendix in front of me. You could give me 1 second.
very first sentence.
Your Honor, here, the facts are undisputed that the stamp itself reads admitted.
Right,
And
I
so-
understand it, but here's the, it seems like the legal question here. If the immigration judge made a finding of fact that this was erroneous to stamp admitted, and you haven't challenged that, wouldn't that be a waiver on your part? And that we would have to take it as a matter of law that there was not an admission?
Your Honor,
You see the question I'm asking?
yes, Your Honor. We still contend that this was not a finding of fact, and that the issue here is, again, the facts here are undisputed about that the stamp reads admitted. It's simply a question of whether the stamp is sufficient to meet the legal standard of an admission. So, I have two more points to make on rebuttal, if it's okay with Your Honors. Ms. Montesinos Cisneros was admitted and not paroled into the country. Opposing counsel argues that because she had an advance parole document, that this means that she was paroled into the country. Simply possessing an advance parole document does not make you a parolee. You are paroled into the country if you present yourself at a port of entry and you are paroled into the country. And that is clearly not what happened here. The immigration here admitted Ms. Montesinos into the country, as we can see through the admitted stamp.
Where should I look at? I want you to make your second point too, but what should I look at to suggest that parole is limited to presenting yourself at a port of entry and being granted parole? Like what's the source of the first part of that?
Your Honor, a USCIS website that lists out what parole is, how a person can be eligible for parole.
It seems like we
states
often
that.
have parole, we often have parole with someone who's not at a port of entry, right? So they're, picked up for being here illegally, and then the decision is made whether to detain them or parole them. That strikes me as like not being at the port of entry. Maybe this doesn't matter. I'm just curious why the port of entry matters in that context.
Your Honor, I believe that section was looking at when a person is going to use, has like an advanced parole document. And so USCIS was clarifying that simply having an advanced parole document doesn't mean that you're a parolee. You have to actually be paroled at a port of entry.
Can
Yes, Your
you
Honor.
respond to what opposing counsel said about no status is not status, and that here there was no status?
Yes, Your Honor. Status is not defined in the INA. All we concede from other dictionary definitions is that it means a person's legal condition. And DED, something that changes a person's legal condition, and DED certainly does that. And that is why it is a status, especially for the purposes of this subsection, which read any status. Yes. Lastly, an admission only denotes procedural regularity. Opposing counsel tried to kind of say that this section should be read together as admitted in any status. Tula Rubio and Saldivar, the Fifth and the Ninth Circuit cases, they were dealing with this specific subsection about cancellation of removal, and they read these two separately. And they had matter of quilanta and procedural regularity applied to admission, and then any status, they read it broadly. And Ms. Montesinos was admitted. Oh, sorry, Your Honors, I noticed that my time is up. But yes.
All
Ms.
right,
Montesinos.
thank you very much. We're going to come down and greet counsel and send our video greetings to Mr. Robbins. And there
Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, please be seated. I'll take up our last case, Samuel Sherbrooke Corporate versus Mayor, Mr. Benzinger.
Good morning, Your Honors. Dylan Bensinger from McGuire Woods on behalf of Appellant Samuel Sherbrooke Corporate Limited and Samuel Goldner. May it please the Court, this appeal concerns a textbook example of trade secret misappropriation that the appellees have spent quite a bit of time and effort and money trying to disguise. Each of the appellees were officers and directors of Sherbrooke, and during their employment, they either created or implemented a unique software program that allowed Sherbrooke to more competitively offer profitable insurance products to nursing homes around the country. Each appellee during their employment or before their employment signed.
Did they both have, did all the defendants, in addition to being officers and directors, did they also have ownership interests?
They were minority owners of the business, but they.
Is that true for all of them? As I know some of them were, but were they all minority owners?
My recollection is that at least Queen and Mayor were. Walker may have been as well, but for purposes of this appeal, what's important is that they were all officers and directors of the company, meaning they had the keys to the company. They were able to control the information within the company, and they had access to it on a day-to-day basis.
So it looks like you have two issues here. One is misappropriation, but the threshold issue is there a trade secret? And the district court found that had been inadequately pled, that the complaint had only pled the language of the statute. So why don't you start there, because if you don't have a trade secret, we don't need to deal with misappropriation.
Absolutely, Your Honor. And the complaint absolutely did not simply allege the language of the statute. Judge Boyle below respectfully made the same analytical mistake with respect to both the confidentiality and protectability element and the misappropriation element. He focused myopically on a single allegation in the complaint, decided that complaint was too conclusory to support the claim, and ignored allegations throughout the complaint that supported that conclusion. So with respect to the confidentiality of the trade secret here, this is the picture that the complaint paints. The software was created by Mr. Walker, one of the appellees, who Sherbrooke hired for the specific purpose of creating.
So there are two places in the complaint where it's pled that Sherbrooke used all commercially reasonable measures to ensure that the proprietary software remains confidential, provides unique value. So that's what the statute requires you to plead. What ties that to any other allegations in the complaint?
Sure, that allegation is in the complaint, but that's a guidepost that you can view the rest of the allegations through.
But I take it you would agree if that was all there was, that would not be sufficient.
Sure, if that was all there was, that would not be sufficient. But that's not all there is in the complaint. The complaint makes very clear how this proprietary software was created. It was created in-house by an employee hired specifically to do that. It gave the company a competitive advantage over its rivals in the industry. It spent over $1 million to develop this proprietary software. And the second it learned that the software had escaped the control of the company, it sent a cease and desist demand to the appellees for them to return the property to Sherbrooke. By the way,
Go ahead.
Which paragraphs of the complaint tie the confidentiality agreement to the proprietary software?
so there is a allegation at paragraph 74 of the complaint, this is JA 22, that says that the appellees violated the confidentiality provision by using the proprietary software. It's not a very large logical leap to determine that if someone has violated the confidentiality provision by using the proprietary software, that the proprietary software falls within the meaning of the confidentiality provision in
Even
the
if
first
we
place.
accept all that is true, how does that translate into pleading all commercially reasonable measures were taken? Isn't that what you're required to plead, much less show?
That's right, Your Honor, and the complaint does plead that commercially reasonable efforts were taken. I'll point you specifically to the employment agreement that includes confidentiality provisions and invention provisions. Those provisions are
All
set
right,
out.
show me the paragraph here in the complaint that gives us the nexus that any other action amounts to all commercially reasonable measures.
Well, I think what Your Honor is driving at is, are there multiple commercially reasonable measures? And the answer to that question is, there doesn't need to be. Under clear Fourth Circuit case law and case law from outside the circuit that we have cited in our briefs, only a confidentiality agreement,
Right,
only.
but do you, theoretically, I would agree with you. But I guess what I'm looking for is where the complaint pleads the confidentiality agreement is the commercially all the commercially reasonable steps we need to take because.
Okay, I have two responses to that, Your Honor. The first is the collection of allegations in the complaint make clear that under the circumstances, these were reasonable. And here's how it does it. This was a small company. It only had a few employees. They were direct colleagues and personal connections of Mr. Goldner. And he went beyond just a handshake agreement. He required each of them to sign these very strict confidentiality provisions that are enforceable under the circumstances. They make very clear that should Sherbrooke employees misappropriate the proprietary confidential information of the company, they've violated in terms of their contract, and they can be liable for contract and trade secret violations. The second point I'll make is that there's no basis in the law for the idea that companies need to use the most perfect commercially reasonable measures available to maintain the secrecy.
Can I ask the question so Judge Agee's question I took to be, you got to connect what was done, and I take what you say is done here in the complaint, is that you've alleged the software system was confidential, it's covered by the confidential provision in the employment agreement. But that's really all that you've alleged that you did, and then there's a cease and desist letter. So maybe that's one more piece after the fact. But I take Judge Agee's question to be, but what you need is to have the because, right? Why that alone is itself reasonable. And you were trying to answer that. I thought your response was going to be, that's the legal conclusion, or that's the conclusion for the jury to draw. All we've got to do is allege the facts that are reasonable. You include the conclusion here that you took all reasonable means, but that doesn't really mean a whole lot. But you've alleged the facts of what you did. Whether that's reasonable is sort of for the jury to decide.
That's exactly right. And Judge Agee, apologies if I misunderstood the point of your question, but I agree completely. It's a quintessential fact question. If a court is to determine how reasonable a secrecy measure was it reasonable enough, that is a fact question to be resolved after the pleading stage, after discovery has been developed. Cases like the DeMarcian case in the Fourth Circuit hold that to be true. And I'll even point to the Appellee's cases, Diamond Power and Amerigas, which they've cited on this reasonableness issue. Those were decided in the summary judgment stage.
We've looked a lot, maybe not as much as we should, but we've looked a lot, to try to find some authoritative answer to what seems like to me the general question here as to whether or not you've gone beyond bare bones of the statutory pleading. And we have yet to find a case, maybe you can supply one, where there aren't multiple actions for the confidentiality agreement. There are software safeguards that are undertaken, and so it's hard to find a case that really fits it, where essentially the only thing you've got is the confidentiality agreement.
I'll point you to two cases, Your Honor.
All right, that'd be good.
The first is from the Seventh Circuit. It's the learning curve case that we've cited in our briefing. That case, the Seventh Circuit based a ruling overturning the district court that the secrecy measures were adequate to confer DTSA protection on just a verbal confidentiality agreement that took place during a business meeting between two companies. There was no paper that controlled that meeting, there was no written confidentiality agreement, and there was no other reasonable measure to safeguard the secrecy of the trade secrets at issue. All it was a handshake agreement, and the Seventh Circuit held that the jury would have been entitled to find for the trade secret plaintiff in that case based on those reasonable safety measures. The second case I'll point you to is the Hawkins case.
And this just, give me Hawkins first.
Sure, Your Honor. Hawkins is from the Western District of Virginia. The facts of that case are fairly similar to this one. It involved a small company that created a software product. One of the officers and directors of that company took the software to another company that him and his friends owned, used it to compete directly against the company that he worked for, and the court held, based on the existence of an employment agreement that had confidentiality provisions in it and nothing else, that the trade secret received DTSA protection. The MAI Systems case, which is the Ninth Circuit case in our briefing, also holds, it reaches a similar conclusion.
And the principle that I took out of Learning Curve is that it's just highly context specific, what is reasonable. And it would be a very different question of what is reasonable for a one-man or a two-man shop with trade secrets than it might be for Coca-Cola's recipe for the entity, because the costs and benefits are sort of the quintessential jury question to determine whether these were reasonable in light of the relative costs and the relative benefits of doing what was done.
Right, absolutely. It's a reasonableness analysis. Reasonableness is a fact question. My point in response to Judge Agee's question is that it was an error for Judge Boyle to hold below that as a matter of law, it was unreasonable to use only confidentiality provisions in the contract. That's not the case. What the court should have done is exactly what you, Judge Richardson, are suggesting. Take a look at all the facts that are alleged in the complaint, take stock of what would have been reasonable under the circumstances, and make a decision based on the allegations. What the court did not do is consider at any point whether this decision should be made after a full factual record has been developed in discovery. And that's exactly what we ask that the court should have done. We ask what this court remands for that court to do.
And is there any heightened pleading standard in trade secret cases?
There is under North Carolina state law. There is not under the DTSA. Our claim is under the Federal Defend Trade Secrets Act claim. Cases like HESCA that we've cited in our briefs make clear that there is a difference in the level of pleading specificity that's required in federal law and in state law. It looks like the court below held us to the artificially high pleading standard under North Carolina state law because Judge Boyle cited to the VRX case, and in a parenthetical to that citation, he said that the two statutes are substantially similar. That was right after he faulted us, in his opinion, for failing to allege misappropriation with enough factual enhancement. That all looks to us like he held us to the North Carolina standard, which does not apply here. HESCA makes clear that the two standards are different. All that governs here is the normal Rule 8 plausibility standard, and the allegations of the complaint with respect to misappropriation are more than enough to clear that hurdle.
All right, if we assume you have a trade secret, you want to tell us anything more about the misappropriation?
Sure.
We spent most of the time on the trade secret.
Sure, and I'm happy to address misappropriation more in rebuttal if that's what needs to happen. But we think that Judge Boyle made the same mistake with respect to misappropriation that he did with respect to the trade secret. He focused on that conclusion that's supposed to serve only as a fine point on the allegations in the complaint, ignored the rest of the allegations, and determined that the allegations were insufficient to state a claim for trade secret misappropriation. And once again, here is what the complaint says about how the trade secret was misappropriated. Mr. Walker was hired specifically to create this trade secret in-house. He had the technical knowledge to create and operate this trade secret. He and the other two appellants used this trade secret on a day-to-day basis inside Sherbrooke in order to run the company. And the trade secret itself, the proprietary software, has an extremely narrow purpose. It's an important one to the company, but it's an extremely narrow purpose. All it does is allow insurance companies that write policies to nursing homes to better assess risk and better write insurance policies that are competitive in the market and profitable for the insurance company. Now, when they started their own company, left Sherbrooke, and retained control over literally all of the corporate records and controls that Sherbrooke possessed, the bank accounts, the email server, the business records. They took with them all of those things to this competing company and stood up a company that competes directly against Sherbrooke for the same customers, operating the same business model and in the same geographic regions. All of that together is more than plausible enough to show that the competing company misappropriated the trade secret at issue here.
All right, thank you, Mr. Benziger. You've got some rebuttal time. Mr. Pardue?
Thank you, Your Honors. May it please the court, I'm David Pardue. It's my first time in the Fourth Circuit, so I'm pleased to be here. Appreciate everybody coming under the circumstances. Judge Richardson, you were on the panel in the Cisco Machinery versus DCS case that Judge Boyle ruled on, and in which Judge Wilkinson's opinion talks about how that wasn't enough to plead a trade secrets case. I noticed that you talked about context. That is important here. One of the things that's a fact in this case that is not disputed is that Sherbrooke is a captive insurance company. It is a North Carolina captive insurance company. In our answer, so we're on a Rule 12C motion, so what's in our answer is in the record, and we say in there, they can only write policies for Sam Goldner's nursing homes. So in the hearing below, Judge Boyle was quite interested in how is their competition? There can't be competition because Sherbrooke is a captive insurance
All
company.
right, so assume I agree with all that. Why does that matter at all for the trade secret misappropriation? Just connect that for me. I understand that, like, conceptually, your colleague on the other side wanted to talk about competition. You want to say there's no competition, but it's not obvious to me why that matters for the trade secret misappropriation. If you had taken this software and gone to Hawaii, where there's no sense of them being there, and you had used it there, it seems like that would be a trade secret misappropriation. Maybe there are no damages, acknowledge that, but why does that matter for the appeal?
Well, I think it does matter in that, the first prong is there a trade secret? And the Cisco case talks about Twombly and, what Twombly means. That was obviously an antitrust case, but the case is saying, that you have to plead something
Counsel,
more.
let me ask you kind of dissecting Judge Richardson's question. Does the fact that there's a captive insurance company have any impact on the threshold question of whether or not there's a trade secret, putting aside the question of misappropriation?
Well, in reality, you could not be having a captive insurance company and allege that somebody has a software that helps you price insurance policies when the only insurance policies that you're dealing with are insurance policies for Sam Goldner, who is the insured. It just doesn't make any sense. I do understand how you're saying, well, how is it
I totally
relevant?
understand. This is a great jury argument. I'm totally understand the point I think you're trying to make, which might well be super interesting at some point in the future. But what I don't understand is, why is it relevant to whether they took reasonable means to keep the software confidential? Like, do you agree it has nothing to do with that?
I think it's not relevant to whether they took reasonable means or not.
Can you then sort of switch for a minute? Because I'm sort of interested in this question of what more were they required to do? So they had to take reasonable measures. From your perspective, what else did they have to do in order to have plausibly alleged that they took reasonable measures? Like what else? Did they need a password? Did they need Like, what else do you think they needed to allege in order to plausibly have alleged such that a jury could find that what they took was what they did was reasonable?
Great question. So first, the question is, can they just say, hey, there's a confidentiality agreement, so we took commercially reasonable measures? Quite possibly they could, actually. You could have a 40-page confidentiality provision.
Well, that's what they did here. That's the allegation. Why isn't the allegation about the confidentiality agreement sufficient in the context of the complaint and the stage of the litigation we're at?
Great question. Judge E.G., I noticed earlier you were talking about how that lending case, it seemed like nobody there had ever done a real estate deal. I do this for a living. I do these contracts. I do these cases. There is no, so they have in here a snippet of a alleged contract that says you cannot disclose confidential information. There is no definition whatsoever in the pleading
All right, so
about
can you-
what's confidential.
Can you go back to my question, right, which is, what else were they required to do? Like, give me, not, they could just do this or they could do that, but like, tell me what, like, they need, you say this fails. What is the paragraph that they needed that would have, you say that you do this, and so what is it that they needed to say? Like, give me the 3 sentences or 1 sentence or 1 phrase, or like, tell me the 2.5 pages that they needed to say in order to plausibly allege that what they did was reasonable.
Great question. They need to say, these are reasonable measures because there's a confidentiality agreement.
Wait, but
and
that's a
be
conclusion,
cau-
right? Wait, stop, because that doesn't help you, right? So that's just the conclusion of whether they're reasonable or not. They give the conclusion, they say we took reasonable measures. They also tell us what they did, that is this. They don't have to explain why that is itself reasonable. Like, that's not what the pleading standard requires, right? This is a fact-based pleading. So what I'm asking is, what else were they required to do? What were they required to allege that they had done? Like a password, like a, you know, I don't really know what else it is that you want them to have done. I'm trying to figure out, what is it that you wanted them to have done that they needed to do in order to pass the pleading stage of reasonable measures?
They have to say what is confidential information. It's a
Okay,
capitalized
so
term.
I understand that. So in your view, if they had said, just to, you know, to take as an example, right? If they had said that the proprietary software is the confidential property of Sherbrooke, like that would answer that question, right? Because we would now
In the
know.
contract, yes.
All right, so in case you're wondering, I'm just reading from paragraph 44, right? So like,
Right.
they said that. So what else did they require them to say? So what else was needed to be in the complaint to plausibly allege that they took reasonable measures? Like, tell me, like, what are the words that they needed to include that aren't there?
So in paragraph 44, how does Walker know? They just say it was confidential. The contract doesn't say it was confidential.
Well-
It doesn't say anything is confidential.
I think
First
the-
of all,
the
Walker's.
question, the underlying question is whether or not that's a pleading defect or whether or not that would be a defect on the merits. If it got that, seems like to me that's the issue.
It's a pleading defect because
Well,
you
do you
cannot-
agree with
you can't-
opposing counsel that there's not a heightened pleading standard applicable here?
Judge Boyle did not use a heightened pleading standard.
And you agree that there's not a heightened pleading standard for the Defense of Trade Secrets Act, correct?
Under Cisco, yes. Under Cisco, Twombly, Iqbal, not enough. Reasonable measures in the common law, which is developed, because there are cases dismissing lots of plaintiffs for saying, we had reasonable measures, no, you didn't. So they exist.
Give me the best example of a case you've got that says that we should be doing that at the Rule 12 stage, right? Because when I read the cases, they all seem to say pretty clearly some version of that only in extreme cases can what a reasonable precaution be determined as a matter of law, because the answer depends on balancing the costs and benefits that vary from case to case. It's a jury question. Right, so what's the best case that tells me that we should be determining what is reasonable at the Rule 12 stage?
Well, Diamond Power from Georgia that we cite, and there's another case that we cite, you can't just plead that there's a confidentiality agreement under that
Well,
case law, which is where I practice. So that's a
Wait, but
barrier.
I thought you started earlier by saying you could just plead a confidentiality agreement. You
No.
just think they didn't do a good job here.
No. You can't just plead confidentiality agreement, which is all they say, confidentiality agreement. You have to say, where is there a statement that something, anything, is actually confidential? And to answer your other question, the case law has developed that there's three kinds of ways that you can do this. One is through contract, another is through what they call physical barriers, and then the third is through login, password, et cetera, et cetera, et cetera. All of the cases have combinations
And what do you
of
think
that.
they have, did they have to have a password or a physical barrier? Did they need a lock and key on the office? I
There
assume they
are
probably had
cases
one,
that
but maybe
rely on that.
if they had alleged that, right, our front door has a lock, and you have to have a key to open the front door to our business. Would that in your mind now be reasonable?
It would
But
be
the fact
better.
that maybe they don't have any door, they like work outside is like, means they weren't reasonable?
That can work, but my hill that I'm dying on is that you can't just say you can't disclose confidential information. You must have more than that to be a reasonable measure. There is no case that I have been able to find where the only thing that's pled is they had a contract that said confidential information, but it doesn't
But
have
is this-
any
let me take-
definition
all right,
of confidential
Let me take you back
information.
to one of Judge Richardson's earlier questions. Do you have anything in a Rule 12 context, not summary judgment, not appeal after verdict, but in a Rule 12 context that basically takes the position you have put forward?
Yes, I mean, the cases in our brief are
Well, tell me what's the
dismissal
best. Tell me,
cases.
okay,
So,
tell me
so
what's the
start
best
with,
one.
the example you gave me was Diamond Power, right? When I asked the question, and Diamond Power is a summary judgment case. So how about find one that's not a summary judgment case?
Excuse me one second. Sorry, excuse me. So, dismissal, design gaps case, which is 2023 Westlaw 8103156. And the Cisco case, Judge Richardson, that you were on, that was a dismissal case. Vanguard Group v. Snipes. which
Okay, and
is,
Design Gaps is a Western District of North Carolina case?
Yes.
It's a district court case, yeah.
Yes, Judge, it's a district court case.
Oh, and so is Vanguard.
And your
yeah.
point of design, you think design gap stands for the proposition that pleading an employment agreement with a confidentiality provision, but nothing else, is insufficient to have alleged reasonable measures?
Yes,
When
because.
I go to design, I don't have it in front of me right now, but when I go to design gaps, that's what I'm gonna find.
Well, every case has its own facts, et cetera,
I
but there's
understand, but
no.
you're saying that if I'm looking for this proposition, that we should dismiss the complaint at the Rule 12 stage because it's insufficient to allege a confidentiality agreement to reasonably protect a trade secret, that the case you want me to look at is design gaps.
Well,
That's
I
what
don't, I
I'm
don't,
just trying to, I want to make sure that I look at.
those are the cases that are dismissal cases that are within the Fourth Circuit. There are legion dismissal cases.
That do the
that-
other things that Judge Richardson said? There are Rule 12 dismissals involving pleading about a confidentiality agreement and trade secrets.
I believe so. I just, the fact that you can't look at any of this and actually find that proprietary software is their definition, inside of their definition of confidential information, is the problem. I mean, they're claiming there's a contract, they have capitalized term.
All right, so when I look at design gaps, just for whatever it's worth, right, at least I confess, I'm reading it pretty quickly, right? But it doesn't seem to have anything to do with reasonable efforts to protect the information, right? They failed to identify what information, right, was confidential, right? But we don't have that problem. We know it's the software, right? We know that answer.
We only know that because they say so. We don't know it from.
That's why it's called an allegation in a complaint.
There's no allegation that they told him it was confidential. There's no allegation that he had any notice that it was confidential. There's no allegation of what it was. There's no allegation. They claim in paragraph 74 that we were taking employees and, trying to take them away. There's no allegation that those employees did or did not have access to what is considered a software.
All right, so to be fair, I did find what you're referring to. They said they didn't take reasonable efforts because they actually published the information that they claimed was a trade secret. Like that's not saying that an employment agreement is insufficient. That's saying that if you publish the information, you can't then say it's confidential.
Your Honor.
That makes pretty good sense to me, right? But that seems like a motion to dismiss question, right? If it's been published, it's not confidential, right? But that doesn't address the question we have.
Well, they don't say whether it's been published or not. They just say there's a software and there's a contract. They don't say they told us what was confidential. They don't say that.
I think that's Judge Richardson's point, that the fact that this wasn't published, and they don't say that, it distinguishes it from the case that you cited to us a minute ago. But there is a Ninth Circuit case that says that allegations about a confidentiality agreement are sufficient to get beyond the pleading stage in a trade secret case.
Yes, that's a 1993 case. It's the only one that's out there. And the case doesn't discuss, it says there's an agreement. It doesn't discuss what the agreement says. It doesn't discuss. And so I would contend under the case law of Twombly and its progeny, that case would be decided differently now, or should have said something about what confidential means.
It's a
in the
1993
context.
case, so in 32 years, the Ninth Circuit has not reversed it, and no other court has said it's wrong.
I don't think that anybody's considered it, but that case exists. If that's what the Fourth Circuit says is needed to be pleaded for reasonable measures, then that option is available to you. I would suggest that in Cisco, they talk about how slippery trade secrets is. It's very difficult. We have to have something in there. Just saying we have something that says you can't use confidential information and, oh, by the way, this thing was confidential, that's as notice-y pleading as I can get, having practiced in this specific type of tort as anywhere. And I do not believe that there's any case other than that one case in the Ninth Circuit that says otherwise. And on the other hand, in defining what is a reasonable basis, there are cases that, and some of them may be summary judgment cases, but at any rate, they say, here's what is necessary to have one. And given that case law, if I was drafting a complaint, I would say, now, I think probably the definition of confidential information and whatever this contract is must be pretty bad for them because they left it out. It's a defined term in a contract. And, there's just nothing to go on that says this software has been protected. They claim themselves that these guys were running the company themselves. By the way, Walker is not an officer and a director, and they don't even, all of these allegations have to do with Queen and Meyer, who were not the people hired to do
Well,
the software.
Mr. Pardue, in your remaining time, if we let's just assume there's a trade secret, not decide that we assume it. Tell us in your remaining minute about misappropriation, because that's a separate finding.
The court held that there was essentially just an information and belief allegation. That, okay, these guys are selling insurance policies, they must be using the same software or something related to the same software as the software that was written before. I would argue that that is too speculative to pass Twombly, Cisco, or any other reasonableness standard of what you're alleging. You're essentially saying, well, because it looks that way over there, then it must be this way. Twombly's about that in a different context. It's saying they were arguing conscious parallelism. The price is this, our price is this, so that price must be collusion. Here they're alleging, well, you must be using a software to sell insurance policies because you work for us, and that's what that software did. They don't really say what they actually think is going on with my clients. Helios, by the way, is a captive insurance manager company. It's a defendant. That's just something that you have to have in North Carolina if you have a captive insurance company. It's just managing the affairs.
All right. Mr. Pardue, you're over time. Is there anything you want to tell us very, very quickly to sum up?
If the standard is, if you just say you have a confidentiality agreement without any need to define what the things are that are confidential, that is going to be a major problem in business, because anybody can say that. Anybody can say, you signed something, you said confidential, and therefore, everything was confidential. I mean, the Cisco case is saying, based on what they're talking about in that case, all of the business's information is confidential. Same thing here. Based on this, what's confidential information could cover everything possible. Now, they're saying that it covers the software, but there's no, they don't include the contract provision.
I think we've kind of plowed that ground.
So that's,
Okay, I think we've kind
I
of plowed
appreciate your
that ground.
time.
Yes, sir, thank you very much. And now we'll hear Mr. Benzinger. You've got some rebuttal time.
Thank you, Your Honor. I'd like to clear up a couple of factual points and then move to a couple of the cases. I heard counsel say that Walker was not an officer and director of Sherbrooke. Paragraph 40 of the complaint alleges that Walker was hired specifically to be the chief technical officer of Sherbrooke. We heard a lot about the Cisco and design gaps cases. I'll start with design gaps because Judge Richardson went there already. You're correct, Judge Richardson, that the primary reason the court dismissed that trade secret claim is because the plaintiff in that case alleged the existence of a trade secret just by listing very vague types of things that could be trade secrets, business records, customer lists. We've far exceeded that sort of pleading here. The Cisco case it takes a little bit more in-depth analysis to understand why it's distinguishable, but it absolutely is distinguishable here. That case involved Cisco, the plaintiff, that filed a trade secret action against a third-party distributor of its products in the United States. The misappropriation it alleged was that former employees had access to electronic records, took them to a competitor, and used it at the competitor to compete against Cisco. The court dismissed the trade secret claims not because they were insufficient to state trade secret misappropriation claims against those employees, but because Cisco sued the distributor, and the distributor was not the party that did the misappropriation. In fact, the district court there made clear that the allegations as to the distributor were insufficient, as opposed to, that's a quote, as opposed to the former employees. Here, Sherbrooke and Goldner didn't make that same mistake. They didn't sue a third party uninvolved in the misappropriation. They sued the exact employees that did the misappropriation. I'd also like to talk about the argument that somehow the allegations about the tie between the confidentiality provision and the proprietary software are insufficient at the pleading stage. I think I covered this in the opening presentation, but there's allegations up and down the complaint that show how this proprietary software was created, why it was confidential to Sherbrooke, the benefit that its confidentiality gave to Sherbrooke, and as I mentioned in response to Judge Thacker's question, the fact that, or the allegation that the appellees violated the confidentiality provision by using the proprietary software. And if, my position is that those allegations are more than enough to create that nexus that counsel was asking for, but I'll just remind the panel that we also get the benefit of all reasonable inferences that can be drawn in our favor at this stage, because this is a Rule 12 motion. So if the court's decision is that that tie is not explicitly made, it is extremely reasonable to infer that the confidentiality provision covered the one piece of proprietary software that Sherbrooke spent $1 million to create and hired employees specifically to carry out within Sherbrooke. One piece of just broader factual context I'd like to give the court is that Sherbrooke was, unable to meet this heightened pleading standard that Judge Boyle held us to below because the appellees were the ones in control of all of this information. Now, again, the lead position is that under the normal Rule 8 standard, these allegations are sufficient. But to the extent this court, like Judge Boyle, wants us to meet some heightened pleading standard that does not actually apply in the DTSA context, it's important to keep in mind that at the time we filed the complaint, we were still in a world where the appellees were in control of the bank records of Sherbrooke, in control of the business records of Sherbrooke. You'll see in the transcript in the motion for judgment on the pleadings hearing below that 8 months after we filed this complaint, we didn't even have access to our emails back. They still had our email server locked down and prevented us from getting the information that we would have needed to satisfy what is essentially a Rule 9 heightened specificity, heightened particularity standard. So it would have been impossible for us to meet that standard because the defendants that we were suing were preventing us from doing so. So with that factual context in mind, I'd ask that this panel reverse the decision below and remand for further proceedings and allow the case to proceed to discovery. Thank you.
Thank you very much. I'll ask the clerk to adjourn court for the day, and we'll come down and greet counsel.
Stop.